The South African Cabinet has approved the Restitution of Land Rights Amendment Bill, which proposes that the deadline for all land claims be extended to 2018. It means if you did not claim for land restitution before the cutoff date 15 years ago, you can now do so. Is this the solution to the land question South Africa has been looking for? Or, as some claim, will it empower traditional leaders and marginalize women and rural communities? My guests are Thami Mdontswa, the Deputy Chief Land Claims Commissioner, and gender activist Nombosiso Gasa. Guys, welcome to the show. Let me start with you, Thami. I have to say, I don't understand why this bill is even before lawmakers now. You have 9,000 claims outstanding, so you haven't actually finished the job that you do by 2014. You had a target of 30% of land redistributed to restituted to black people by 2014. Now you're opening up the process for more work, which you seemingly can handle.
Justice, I think you will recall that government was reconfigured in 2009, resulting in the creation of the Department of Rural Development and Land Reform. That department took over the work that was done by the Department of Land Affairs. Immediately, the mandates of the two departments were very different, and immediately work had to be done to then align the policies and implementation models of land affairs to the new mandate of rural development and land reform. That culminated in a green paper in 2011, which made various proposals about land reform. The Restitution of Land Rights Amendment Bill is one of the proposals that are coming from that green paper. We've got other policies and other legislation that is currently being developed to give effect to the green paper. No, but let's stick
to the practical aspect of it. That's policy and so forth, and I sort of understand that, but you're not doing the job. You've missed your target. President Zuma said in Parliament in February, we will not reach the 30% by 2014. You've got 9,000 people out there, 9,000 claims, not even people, 9,000 claims. People saying, please, that's my land, deal with this. You can't deal with it. And you're asking for 390,000 by your department's estimate. 390,000 new claimants will be coming through.
Those were people that have been left out. The process, like I said, was started in 2009. It is now that it is where it is, at the level where we now can request Parliament to then process the bill that Cabinet has approved, to open the door for all the people that who are eligible, who are deserving, but who could not participate in the process.
Nombosiso Gasa, I have to say, this, for me, I look at this and I say, look, if my grandmother, my mother, my father had their land taken away from them because of apartheid laws, this is fantastic. They should get the land back. Why are you unhappy with this?
Well, bill? I mean, first and foremost, for almost 2 years, when the conversation started in earnest about revisiting or amending the Land Act, the thing that was in the foreground was that it would go prior to 1913, right? This bill doesn't do that. It sticks to 1913. Secondly, it was supposed to recognize the rights and enforce the rights of individuals that were left out of that process, as he says. There are a number of issues that arise out of this, which are also related to other bills, which this amendment does not resolve. And every time the minister speaks or anybody from government confuses that and therefore confuses the public. One, there is a clear unwillingness on the side of the department to implement the Community Property Act and ensure that community property associations, CPAs, that in fact make meaningful land restitution in communities, that they are registered. I have here an affidavit from somebody from the department who makes it very clear that the definition of community is very much linked to the definition that goes with community as contested by traditional leaders.
I'm going to ask Thami to respond to those two
issues.
It's
all very well and good for the department to say we don't have traditional leaders in this bill, but we know for a fact that no law sits in isolation. Secondly, as I was coming here, I was listening to the radio, and I heard the Khoi and the Sen communities that they're only now establishing a committee of 5 people. So one wonders.
Okay, I'm going to stop you, and I'd like you to respond to the 1913 issue in particular, because that's what President Zuma said, and I thought this is what this bill was all about. So.
The President, in the State of the Nation address in 2013 on the 14th of February, spoke about two things. He spoke about proposals to reopen the lodgement of claims by those who did not do so by the deadline of 31 December 98. He then also mentioned that also to be explored are exceptions to the 1913 cutoff date to accommodate the Khoi and the Sen and claims on heritage sites and historical landmarks. We then adopted a three-phased approach into implementing those policy pronouncements. We said we are going to start with the reopening of the lodgement of claims, and then as phase 1. As phase 2 of that, we would then relook at the regulations that regulate the restitution process to address some of the implementation challenge that exist. And then thirdly, we would then look at the issue of the exceptions. Are you saying
if my parents were moved off their land before 1913, you're now saying, no, I can't?
We are saying policy and legislation for the exceptions to the 1913 cutoff date are being developed, and we have been working on this.
So Nombosiso Gasa is right. You are backtracking on the 1913 issue, and therefore the Khoi and the San in particular will not be getting any land.
We are not backtracking. We are working on policy. The issue of the Khoi and the San is the issue of dispossessions before 1913 is a complex one, and we recognize that, and we said we were going to meet the policy pronouncement by reopening, then immediately follow up on the issues of the Khoi and the San.
But Gasa, you do recognize that if we go back to before 1913, you're going to need a constitutional change. The ANC, and I'm not saying...
It's an incredibly complex issue. And this is what we always find, that government puts the horse at the cart before the horse. They know that there are constitutional implications, right? And there's a difference between the political rhetoric that is being said out there and what is actually being implemented. Even when we talk about this issue of not meeting deadlines, right? It's not just the failure, by the way, of people not meeting the deadline in terms of application. Some of the backlog has arisen from the department itself, and it arose particularly because of lack of political will. To ensure that land restitution is being addressed and is addressed in a fair way. Let's take another issue that is related to the issue of land restitution. Let's go back to the Constitution. The entire interpretation of government policy is based on willing buyer, willing seller, right?
No, but that's been changed.
No, wait a minute. It's based on willing buyer, willing seller, right? The changes are tinkering. What they have not done and continue not to do is to look at the political and the policy implementation and translation of the Constitution in a way
but that's land reform. That's land reform, not land restitution. Restitution is when he says Justice Malala's parents came here, instituted apartheid, and took my farm away. This is the issue.
If you are coming to restitution, and I'm glad that is here, you are even coming to a messy process. Because if you look at the tenure reform system right now that has come out of the department, which is part of that, in fact, the security of tenure, you've got to prove that you are worthy of having the security of tenure if you're a farm dweller.
You should answer that.
I think Ms. Gasa is misunderstanding and confusing various processes. There are quite a number of policy initiatives that are currently being undertaken in the department. The review of the willing buyer, willing seller, that was done, a decision has been taken, and it's clear. We have currently the property valuation bill, which will establish the office of the Valuer General, which will set norms and standards on valuation. That will address the issue of the willing buyer, willing seller. I'm going to stop you
there because you've dealt with the issues. I want to ask you, both of you, we've got 2 minutes. I really want to deal with this. Traditional leaders in this bill, Thami, in this bill, it seems like you're saying, okay, Justice Malala and the community of Hammanskraal claim your land, and then the next minute you're saying no. And that's part of the argument, I think, being made by Nombosiso Gasa. You're saying, no, the traditional leaders will actually have oversight and ownership of this land.
Justice, there's 2 ways to settle a claim. The first is by the minister, and the second is by the court. And when the minister and the court are awarding land, in the current Restitution Act, a provision that is not being changed. They are each required to ensure that each household in a community has access to the land on a basis that is fair and non-discriminatory.
They want to have the land back. But Nombosiso, Gasa, how do you respond to that?
The department is actually playing politics, and it's playing politics with something that is very, very serious in this country. Here's an example, reported by New Age on the 4th of April 2013. King Zwelithini calls a meeting, discusses with Amakosi in KZN how he's going to help them to claim the land, and then he says he's going to appeal to...
but that's not the law. That's the King of the Zulu.
Wait a minute. He says in this thing that he's going to appeal to President Zuma and Premier Mkhize as Zulu people to go and claim so that they can hold. A month later, a month or two later, this thing comes in. So there is a game that is being played somewhere. One of the questions that we need to ask is, why now? And this is what makes us uncomfortable with this.
We've run out of time. Thami, you get the last word, 20 seconds.
The work was started in 2009. The Green Paper was published in 2011. It's government processes that have seen us being where we are currently. It has absolutely nothing to do with politics.
In March 2013, your chief director in the department, in fact, raised the same issue, and in fact, he came up with that green paper, and it was very different from what you are saying. And the actual bill is very different. You're playing with
Thanks
people.
so much, both of you, for your time. We're going to have this discussion again, and we're going to have more time for it. It's very interesting. Thanks so much. After the break, our winner and loser of the week. Stay with us.
News that moves. enca.com.